All right. Good evening, everyone. It's 7 o'clock, so we're going to make a start. And welcome to the Thames Valley branch of the Chartered Institute of Arbitrators event this evening. I'm James Richardson. I'm the branch chair, and I'm just going to do a brief introduction before I hand over to the main attraction. Very briefly about the branch, we're broadly speaking bucks, barks, and ox. So we try and get around the branch as much as possible. We're up in Oxford from time to time. We've had events in Milton Keynes. Today we're in Maidenhead, and our next event is in Reading. So really do try and get around the branch as much as we can. Anyone online who's in the Reading area, we really hope to see you at our May event, which is on the 21st of May. And we're going to be talking about, or we're going to be hearing about, the rising demand for alternatives to university, and a challenge to that conventional wisdom of university being essential, particularly for professional jobs, and instead the opportunities to do things such as degree apprenticeships and other routes that are now being offered, and why they might be interesting or attractive for people coming through and coming into our professions, and what we can do to better facilitate that. So we're really looking forward to that event. But tonight we've got Nick Kaplan here to speak to us, and he's going to be talking to us about termination. Now, Nick is a barrister, but you've been heavily involved with the RICS, arbitrators, adjudicators, and I think you spoke at Arbrix as well quite recently. And I've got on my sheet described as a rising star of the construction law and adjudication aspects of the bar. And I feel a bit awkward saying rising star to someone who is actually so eminent. I mean, it feels the wrong term, but Nick's been really active, and we're really lucky and really grateful to have you coming to speak to us today. Nick's a direct access barrister, and he acts for adjudicators as well as employers, contractors and subcontractors, and has recently been involved in one of the cases which we're going to be hearing about tonight in front of the Supreme Court. So, Nick, we're really pleased to have you here this evening, and I'm going to let you get on with it. So thank you very much.
Thank you very much for the introduction, James, and thank you, Mark, for the invitation to speak, and thank you everyone for attending this evening. So as James says, the subject matter of the talk is terminating construction contracts, principles, pitfalls, and the case of Providence. A short agenda for what I plan to cover this evening. So starting with some general principles, setting out how termination works and what its effects are. And I think for present purposes, it's important to highlight that termination is usually referred to or thought of as the nuclear option under any form of contract, really. And yes, sorry, you're struggling. Yes, it's well known to be a process that is fraught with risk and tripwires, certainly for the unwary. So I will start, as I say, by going through some general principles, outlining how the process works, drawing some distinctions between termination at common law and termination under a contractual code, and drawing out some of the risks and difficulties and how one might avoid them and navigate them. And then I will move on to engage in a bit of shameless self-promotion and talk about a case that I've recently been involved in that went up to the Supreme Court, talking about some of these issues in the construction context, which is Providence and Hexagon. So, general principles. To start with a little bit of an overview. So, first point, all breaches of a contract will entitle the innocent party to the contract to damages, to a claim for damages. But not all breaches, of course, will entitle a party to terminate. In order to be entitled to terminate, the breach must be known as what we refer to as a repudiatory breach. And I'll come on to discuss in a moment a little bit more what amounts to a repudiatory breach. But it's one that's sufficiently serious And it says on the slides, a repudiatory breach generally allows for termination. There are some exceptions to that in very unusual circumstances. If you've got a contractual code that excludes the right to terminate for repudiatory breach, but that's extremely rare. And conversely, you can have contractual clauses that allow a party to terminate for reasons or on grounds that may be less than repudiatory. Indeed, you can have contractual provisions that allow you to terminate for convenience. And I think that the key thing that I want to stress as we start is that a wrongful attempt to terminate, whether that be purporting to accept a repudiatory breach or trying to terminate under a contractual code and getting the process wrong, can itself put you in repudiatory breach, entitling the other party to terminate. And that is the main thing about which one needs to be very, very careful when you're terminating. Just to outline the effects of termination, what it does is it ends the ongoing obligations of the parties, but it doesn't have any effect on rights that have already unconditionally accrued before the date of termination. It replaces the ongoing obligations with rights in both directions, sometimes to claim damages, and often how that will work is something that will be governed by the express terms of the contract, but that's not the case all the time. The last thing to mention here is that therefore how the effect that termination has will turn on the proper construction of the contract and termination provisions. And the courts generally stress, although there is some tension in the authorities about this, that there are no unusual or special principles that apply to the interpretation of clauses governing termination. It's the same sort of test that one uses for any other contractual interpretation issue. So moving on, what is a repudiatory breach? I've outlined two types. The first being renunciation, which is words or conduct that evince an intention by the party who's repudiated to not perform their obligations in some essential respect. So an instruction to a contractor that it should cease all works or that it should leave site, if that's issued by the employer, will almost certainly be repudiatory unless there is a contractual basis on which to give such an instruction. Similarly, as I've already mentioned, a notice purporting to accept a repudiatory breach that's invalid can itself amount to renunciation of a contract. The other way of looking at repudiatory breach is on a failure to perform grounds. So if there has been a total or partial failure to perform some obligation that goes to the root of the contract, so it has to be one that is really of the essence of the contract. So in an employer's case, it may be repeated instances, not merely of late payment, but of non-payment. That could be repudiatory. And in a contractor's terms, failing to carry out essential aspects of the work. So contractual termination provisions, by contrast, don't necessarily require such a high threshold to meet. Really, the parties are free under their contract to agree whatever they like by way of a trigger to termination. So they can define the circumstances in which the contract can be terminated. Now, an example that you often see, they're not really so much in the standard forms in the construction industry, but you see them in bespoke contracts quite often, is the expression any material breach will allow for termination. And that will inherently involve a judgment call as to what a material breach is. But the authorities will generally suggest, albeit one needs to interpret them in the context of each individual contract in itself, but as a general matter, a material breach is one that's less than de minimis or trivial, but doesn't have to be so serious as to be the equivalent of being repudiatory. So it's a lower standard. The standard forms in the construction industry, the JCT in particular, which we'll come on to discuss in detail in the latter half of this talk, have provisions that allow for termination in the event of certain specified defaults. occurring. So on the employer side, failure to make payment is a specified default. And if the default occurs, there's a series of provisions that allow the contractor eventually to terminate, either if that default is continued for a period of time or if it's repeated. And then finally, I've already mentioned provisions that allow termination for convenience. That is a provision that allows termination without any reason having to be given at all. Often the contract will specify a process by which that happens, and usually it will be on a certain number of days' notice, and one would expect the contract then to go on to specify the consequences of termination of that kind. That brings us naturally on to the effect of termination under a contract. And starting with some general principles highlighted in the case law. So this is a decision dating back some time now of Lord Wilberforce in the House of Lords. And he outlines that, as I've already really mentioned, that the effect of termination is to bring the primary ongoing obligations of the party to an end. Those are the obligations that are not yet performed, and to substitute those obligations for a secondary obligation to pay damages in one direction or another. What the termination process doesn't do is affect the accrued rights that have arisen prior to the date on which the contract is brought to an end. So if the contractor has done a large quantity of work, hasn't been paid, but the contract is terminated, there will usually, save for some pretty stringent and exceptional contractual terms, the contractor will usually remain entitled to payment for the work that it carried out. So termination prevents the other party being able to insist on any further performance. So that's the party that may otherwise want the contract to continue after the contract's come to an end. They have no right to insist on any further performance. The rights that have accrued have to have, the expression used in the authorities is unconditionally accrued before the party remains entitled.
James, can you take the HDMI out and pop it back in again? Just the HDMI. The screen's gone blank for those online.
Working.
Apologies.
That's all right. So it's where rights have unconditionally been acquired that. Has it gone again? I don't know if I'm dislodging it.
No, you're not at all. It's something else, I'm sure. Yeah, so just for the benefit of those online, we're having some technical difficulty in the room with the projector and the screen. Yeah, please. Right, okay, one moment. Let's try this.
Yeah, magic.
We might have to just keep playing with it, James. All right, sorry about
Okay.
That's all right.
You carry on.
I've got them in front of me. It's really for everyone else's benefits.
Can you do it through the medium of mine?
Next time, they've got to give me some time to prepare for that. Yeah, so the expression unconditionally acquired is an important one, and it's been spelled out in a number of authorities. I've given one of them there, but it means that there has to be no conditionality to the right. So in the event of, say, a payment obligation, if there was a step that needed to be carried out before that obligation would arise, so serving a particular notice, that has to have been served such that the right has unconditionally arisen and not be merely a contingent right. And as I've already said in the introduction, the damages that flow from a termination, particularly a contractual termination, will be understood in light of the contractual terms. Now, that is particularly important where you're talking about a termination for convenience, because if you're terminating for convenience, it means the other party is not in breach. And so there wouldn't be a right on such termination to claim anything from the other party in the event that you exercise a right to terminate for convenience, unless the contract provides otherwise. And it would be an unusual contractual provision that allowed you to terminate for convenience and then claim something from the other party. And so attempts to draft terms like that, and you sometimes see them, particularly where you've had a right to terminate for convenience inserted into a standard form contract that wouldn't otherwise provide for it, you can find yourself in drafting difficulties. You've got a term that becomes void because it operates as a penalty. And you've got a danger there where you've got an express right under the terms as written that says you can terminate, but because the consequences of that haven't been thought through properly and it operates as a penalty, that right is void. And so you could have purported to terminate under what you thought was an express right and find yourself in repudiatory breach. So these are the sorts of things you have to be very careful about. Sometimes you see in contractual provisions rights that are quite different to what you would typically expect if you were just terminating at common law. So, for example, the FIDIC form allows for certain forms of termination that give the employer a right to make use of the contractor's plant and equipment from site for the remaining works that are left to be carried out. Again, those are the sorts of things that you've got to be a little careful about exercising, and I'll come on to discuss why that is in a moment. So now I'm going to turn to look at some of the contrast between contractual and common law termination. By common law termination, I really mean termination for repudiatory breach. And contractual termination is termination under a contractual code. Have we gone again? If I just carry on.
You just carry on, please.
Yeah.
You're moving the slides on online? Okay.
So so it is possible under a contract to exclude what would otherwise be a right to terminate for repudiatory breach, but in order to do that, you need to have very clear words. The authority for that is Modern Engineering, Gilbert, Ash, and it's only going to be in very exceptional circumstances in which that arises, and really only in a bespoke form contract where it's been deliberately drafted in clear terms. None of the standard form contracts have that. Indeed, most of the standard form contracts, certainly the JCT, expressly say that the contractual termination provisions are without prejudice to the other rights and remedies of the party, and that would include the right to terminate for repudiatory breach. So where you have a contractual right to terminate that exists alongside a right to terminate at common law for repudiatory breach, questions arise as to whether or not one can terminate either under the contract or at common law, or whether you're entitled to do both. And there are circumstances in which you can do both, and there are circumstances in which you must do one or the other, and you have to make an election. Now, when you're terminating under the contract, there will typically be a contractual procedure for termination. It will usually involve giving a notice in a particular form to a particular person, and the law on how those notices have to be issued is strict. And there's an authority from the House of Lords saying if the contract says your notice needs to be written on blue paper and you serve it on pink paper, your notice will be invalid, even if it's otherwise completely compliant. So you need to make sure you're following the procedure contractually very carefully. By contrast, terminating for repudiatory breach at common law doesn't require any particular form. It suffices merely to treat the contract as if it was discharged or that you are no longer bound by it.
Sorry, Nick, if we just pause for one
Yes.
moment, we're going to try and resolve this. If we can't resolve this quickly, I think we may have to press on without the benefit of the slides for everyone in the room. The slides will be circulated after the event. So
That's all right.
yeah, so we'll give that another try.
Is that your own cable or one of our cables?
No, that was the cable we found in there. Have you another?
Yes.
Okay, sure.
Try another. I do sometimes. Someone else's one. Let's stick it on.
Thank you.
Sorry, guys.
Thank you very much.
I've got it showing on my screen here now, actually, which is weird because it's unplugged.
You say it's showing on your screen there.
Is there a different port that we could try? There's only one port.
Is that saying HDMI? It said earlier. I didn't think it said two. Ah, HDMI 1. I was going to say it was one earlier. It wasn't source found. Yeah, I was going to say it was one earlier. Yeah, it said found now, and it's showing up on my screen.
Magic.
Okay.
So if it drops that, yeah, number one, you need to fight.
So what we'll do, we'll continue.
Yep.
I won't interrupt you again, Nick. I do apologise
That's
for
all
this.
right.
And apologies if those in the room. If it does drop out, Nick will continue, and then we will circulate the slides after the event.
Yes. Okay. Right. Moving on to the next slide. So whether one needs to elect or not, it's a very important question, or can be, depending on the terms of one's contract. So the view used to be that exercising a contractual right to terminate was itself affirmation of a contract, and so couldn't constitute acceptance of a repudiatory breach. The authority for that I've given there on the first point on the slide. The law has moved on somewhat from that, and it's now clear that, generally speaking, there will not be an inconsistency between terminating at common law and terminating under a contract, because both generally have the same effect. And so in those circumstances, where you've got a contractual regime that gives rise to consequences that are consistent with those that would arise at common law, it is possible to both terminate under the contract and at the same time terminate for acceptance of repudiatory breach at common law. If you've got a regime that is inconsistent, so that the rights that arise on termination for repudiatory breach are inconsistent with those that would arise for terminating at common law, the position is that one must elect whether one's terminating under the contract or whether one's terminating for repudiatory breach. So your notice of termination will have to specify which it is that you're doing. Now, I should stress that this is going to be the unusual case. The circumstance in which it may arise is if you've got something like the FIDIT form that says on termination under a particular contractual provision, you're entitled to make use of the contractor's plant. That would generally be inconsistent with terminating for repudiatory breach at common law, where no such right would arise, because you could only make use of that plant if the contract in some form had continued to exist. And so exercising a clause of that kind is a circumstance in which one would need to elect. Where the rights arise are different but not inconsistent, you can exercise one or the other rights, but you need to make clear which you're doing. And where the rights are identical, you can just give a contractual notice of termination, say in the alternative it counts as an acceptance of a repudiatory breach. And it's important to ascertain which of these three situations you find yourself in, because if you get it wrong in any particular case, unless you're in the fortunate position where the consequences are identical, you can put yourself in repudiatory breach. Now, I'm going to go through this one very quickly, given that time is now marching on. some recent cases to be aware of, or at least the second one is relatively recent, and some principles I think that are somewhat underappreciated. Certainly, I don't see these points argued as often as I would expect them to be. Where you've got a contractual provision allowing you to terminate for convenience, that can give you very powerful protection in circumstances where you've repudiated a contract. Because if you've got that right and the other party purports to accept your repudiatory breach, you've got a handy fallback argument to say, well, if I hadn't repudiated, what I would have done is just terminate on giving you a month's notice or a day's notice. And in those circumstances, there's a not particularly well reported, but I think quite well justified principle that the innocent party is not entitled to a better bargain than the bargain that they actually made, which included the right to terminate for convenience. And so if your termination right allows you to terminate on 1 month's notice, then the most the other side will be entitled to as damages for your repudiatory breach is the month they could have remained on site had you given that notice. But there is a need for caution here, because that principle only operates if the repudiatory breach is accepted and the contract is brought to an end. In circumstances where the repudiatory breach isn't accepted, the other party says, I remain willing to come and do whatever work you want me to do. You just tell me and I'll come straight back to site. And they're treating the contract as continuing. That principle doesn't apply. And the Scottish case, there's no English authority on this, but a Scottish case which found that as a matter of principle. And that's the second case listed on the slide there, Dalton Group and City of Edinburgh Council. Quite an important, I think, somewhat underappreciated decision. So I'm now going to move on to a recent case that I was involved in that somewhat, I think to everyone's surprise, worked its way up to the Supreme Court. And it's a case engaging many of the points that we've been talking about contractual termination. And it was under the JCT form of contract, which is probably the most widely used standard form in construction projects in the UK. And the whole thing really turned on the meaning of 3 words. Those words were for any reason. It took 5 Supreme Court judges, 3 Court of Appeal judges, a deputy judge in the High Court who wrote the text on this, and an adjudicator to decide what those 3 words meant. So never let it be said that lawyers can't make an argument over nothing. Clause 8.9 of the contract is the provision that this all turned on. And that's a provision allowing a contractor to terminate where an employer commits what's known under the contract as a specified default. So the material provisions of the contract I've set out on this and the next slide. And it starts by telling you what the specified defaults are. For the purposes of understanding the case, the only thing that you really need to know is that the specified default in question was a failure to make payment on time. So that's failure to pay by the final date for payment. And where a default of that kind occurs, clause 8.9.1 gives the contractor a right to send the employer a notice saying you've committed a breach that is one of the specified breaches in the contract. So we'll call that a notice of specified default. And then move on. Clause 8.9.2 is not relevant, so we won't consider that. We move on to clause 8.9.3. Clause 8.9.3 provides that where you've sent your notice of specified default, the employer then has a period in the standard wording of the contract of 14 days to put that default right. In the amended form that the parties were using in this case with bespoke amendments, that 14-day period had been changed to 28 days. So 14 or 28 days to put right that default, make the payment essentially. And if that default is not cured within that, what we're calling the cure period, the contractor becomes entitled to terminate. And then clause 8.9.4, which is the clause that the whole dispute turned on, was a provision about terminating for repetition. And it was uncontroversial between the parties that a contractor was entitled to terminate immediately, so that's with no further notice to the employer, if the default, the late payment, was repeated. The dispute was in what circumstances that right to terminate immediately on repetition arose. But the wording of the clause, so that we've got it, and with the controversial bit of the wording highlighted, is that if the contractor for any reason does not give the further notice in clause 8.9.3, i.e. if the contractor doesn't terminate on continuation, but the employer repeats the default, then the contractor may, by notice to the employer, terminate the contractor's employment. And as I say, that the critical thing there is that it's immediate termination without any further period of time having to elapse. So if there's a repetition of the late payment, at least in the right circumstances, you don't need to wait for even a day or a second to elapse. You can immediately pull off site. Just for the purposes of comparison, and because this featured heavily in the reasoning of the Court of Appeal when it considered these issues, there is a mirror provision for allowing the employer to terminate in the event of contractor default. The mirror for clause 8.9.4, which is the controversial clause, is 8.4.3. And that clause provides that if the employer does not give the further notice referred to in the preceding clause, i.e. the continuation notice, whether as a result of the ending of a specified default or otherwise, and I've highlighted that wording because it is a contrast to the wording of 8.9.4, and the default is repeated, then the contractor then the employer is entitled to terminate, and again, immediately to terminate. Now move on to the facts that gave rise to the disputes. This was a case in which my client, Hexagon, was, on any view, guilty of failing to pay on time on a number of occasions. I think the lowest count we could get to was 19 instances of late payment, and that's out of 32 or 3 payment cycles, so not the best record in the world, one might think. It's a housing association, and they have rather cumbersome approvals processes for their payments, and the contractor did not cover itself in glory in terms of making applications in the right form and assisting payment being made. That might be a fight for another day. Now, the critical facts relate to payment cycles. The first payment cycle, 27, where Hexagon was required to pay £264,000 by the 15th of December. Because it was nearing Christmas, Hexagon didn't manage to do that. And on the 16th of December, so the next day, Providence gave its 8.9.1 notice of specified default. Hexagon then paid that sum within the 28-day cure period. It actually also paid within the standard 14 days, so it paid on the 13th day. And then everything went quiet for a while. We come to the payment in payments cycle five along, payment cycle 32, where Hexagon was required to pay just over £360,000, and the date by which it should have done that was the 17th of May. And on any view, that was the right date. That was not in dispute. That date was missed. And the very next day, so not giving any further notice or any opportunity to cure, Providence sent its notice of termination. Now, that termination notice gave 2 grounds. So this is one of the cases where the contractual provisions exist alongside a common law right to terminate for repudiatory breach. And there was no inconsistency between the rights that arise. So the contractor gave 2 grounds to terminate. The first being that there had been a notice of specified default in December, and Hexagon had then repeated the default subsequently. And so immediately upon that repetition, Providence said that it was entitled to terminate because of the May late payment. The second ground that was given was that Hexagon had repeated its late payment on at least 19 instances, and that was such a serious breach that it amounted to a repudiation of the contract, which Providence was electing to accept. Now, both of those issues were issues, or both those grounds for termination were issues within an adjudication that Hexagon started. The adjudicator found that the contractual termination was invalid for reasons that the Supreme Court eventually agreed with. And he also found that the 19 instances of late payment did not amount to a repudiatory breach. And that was largely because the periods of time were trivially small. The amounts of money generally were tiny. In the adjudication, we did a calculation as to how much interest would accrue at the 8% rate on all of those 19 late payments, and it came to about £5,000. So we're not talking about serious defaults, or at least that was the case we made and the case that the adjudicator accepted. Those issues on repudiatory breach were all quite fact heavy, and so weren't the appropriate subject matter of what became Providence's Part 8 claim to have the adjudicator's decision effectively overturned. Providence confined that claim eventually to a claim about how clause 8.9.4 operated. And so the sole issue on the facts as were agreed between the parties about the various instances of late payment was as follows. Can the contractor terminate its employment under clause 8.9.4 of the JCT in a case where the right to give the further notice referred to in clause 8.9.3, that is the notice to terminate for continuation, has never previously accrued? Now, at first instance, the judge reached the very same conclusion that the adjudicator had reached, and that was the argument that Hexagon was making, which is that the only circumstance in which you can terminate immediately on repetition of a employer default is if the right to terminate for continuation of the first default had arisen, i.e. the 28-day cure period had elapsed, but hadn't for any reason been exercised. And we say that was A, a common sense reading of the clause, and B, what it means on its literal language. That's what the reference back to 8.9.3 in clause 8.9.4 is for. The Court of Appeal didn't agree with that. This was a unanimous decision of 3 Lord Justices of Appeal, 2 of whom are probably the most experienced construction judges in the UK. That's Lord Justice Coulson and Lord Justice Stuart Smith, who both were construction barristers in their lives before being judges. And so a powerful Court of Appeal disagreed with our interpretation of the clause. And it's a very well written and well considered and clever, I think, judgment that repays reading, even though it was eventually overturned. And there are a number of reasons that they give, but to my mind, the essential bit of the reasoning is as I've set out at paragraph 29. And this focuses on the literal meaning of the words used. And I would highlight in 2 instances that the court says viewing the clause in isolation, viewing 8.9.4 in isolation, it comes to this reading. And it says that the words, if the contractor, for any reason, does not give the further notice, are broad enough to encompass a state of affairs in which the notice under 8.9.3 did not arise. In effect, the court was saying that one circumstance in which, or one reason why the contractor might not give the further notice under 8.9.3 is that right had never arisen, and that was a reason why you might not give it. And given that the wording is broad, any reason can encompass any reason, what the court says that naturally means that even where the right didn't arise, but the default was nevertheless repeated, you are entitled to terminate immediately on repetition. So effectively, it operates as a yellow card, red card system. You give your notice of specified default, that's your yellow card. And then as soon as you repeat the default, that's your red card, and the contractor's off and home and dry. The Supreme Court did not agree with that reasoning, and it was particularly critical of the Court of Appeal's starting point, which was to view the words of 8.9.4 in its own words in isolation before going on to assess whether contextual factors made any difference to that reading. And in our submissions to the Supreme Court, we said that that got the whole exercise the wrong way around. The authorities are all clear that you've got to construe words of a contract in their commercial and wider contractual context. And the sole question that the Court of Appeal should have asked itself is just, what do those words, when viewed in context, actually mean? By viewing the words in isolation and giving them the very literal interpretation that it did, and then going on to consider whether contextual factors made any difference, we say, and the Supreme Court, I think, accepted that the Court of Appeal was loading the dice against us, as if it was for Hexagon to rebut some presumption that arises from looking at the words in isolation. And really what the Court of Appeal needed to do was look at the words in context and see what they mean. And that's what the Supreme Court does, starting in particular at paragraph 32 of its judgment. So it says, focusing first on the objective, natural meaning of the words in clause 8.9.4, critically, in context of 8.9 as a whole, it recognises that clause 8.9.4, and if we go back to it, you'll see why, is parasitic on clause 8.9.3. Sorry, Mark. We're going back to number 21, if that helps.
Medium of dance going on, yeah.
Apologies. I'd forgotten that I'm not taking you with me.
What number are you on?
Slide 21.
Okay, yeah.
We're gonna leap back forwards again in a moment. So you should see at the bottom of the screen the num. Oh, you can't see that.
We'll find it. Probably just people online.
Yeah. There we go, perfect, thank you. So 8.9.4, we have looked at this earlier. I'm sorry to have taken Mark so far back. The wording is, if the contractor for any reason does not give, and then the critical bit is the further notice referred to in clause 8.9.3. As the court says, just looking at it in its context, you see a clause that flows 8.9.1, goes on to 8.9.3, and then on to 8.9.4. That reference back to 8.9.3 must be there for a reason. And you can see that it must be there for a reason by considering what would happen if you just took out all of the controversial wording. So if clause 8.9.4, if the words the contractor for any reason, etc., all the way to the end of the brackets had just been deleted, and the clause had said, if the employer repeats a specified default, then the contractor can terminate by giving notice immediately. That clause would unambiguously mean what Providence had said the clause meant. And so what is the point of including the words the contractor for any reason does not give the further notice? Well, the purpose that they serve is to make clear that you can only give that notice if you could have given the 8.9.3 continuation notice, but for any reason you didn't do so. And so looking at the words in context and looking at the fact that 8.9.4 is parasitic on 8.9.3, it's clear that the right to terminate for repetition of a default only arises if there was a prior right to terminate for continuation under 8.9.3 and that right was not exercised. So that's what the Supreme Court explains. We're skipping back ahead to the slide 27. I'm not sure that's going to help you very much, but
We're with you.
you're with me. That is essentially what the Supreme Court is saying, much more pithily than I've said it, paragraph 32 of its judgment. The court then went on to look at some of the other reasoning that the Court of Appeal did. So after the Court of Appeal does its literalist reading, viewing the words in isolation, it goes on to assess clause 8.9 in context to see whether contextual factors made any difference. And one thing that the Court of Appeal particularly focused on was clause 8.4. It was common ground between the parties that under clause 8.4, the employer was entitled to terminate for repetition of a contractor default, whether or not the right to terminate for continuation had arisen. We said that that's because the clauses were worded differently, and the bracketed wording that we looked at when we looked at that clause earlier makes it unambiguously clear that you are entitled to terminate whether or not the 8.4.2 right arose. The Court of Appeal looked at both clauses and compared them and said, well, they're both structurally very similar. They both start if the contractual employer doesn't do X or Y, then Z. And given the similarities that the court focused on in both structure and wording of the provisions, it said that the two clauses must mean the same thing. And given that they must mean the same thing, and it's unambiguously the case that the 8.4 operates as Providence said the clauses operated, then it must follow that 8.9 operates in the same way. And the Supreme Court disagreed with all of that analysis. It's wrong to start in isolation. More importantly, in the contextual analysis, it shouldn't have been driven to a reading that ensured parity between clauses 8.9 and clauses 8.4. The reason why the Supreme Court said that was wrong is, firstly, there was no reason to expect symmetry between an employer termination provision and a contract termination provision. And there's no reason to expect symmetry because the obligations of each of the parties are fundamentally different to one another. And so if the parties want to draft their termination provisions differently, they're perfectly free to do so. They say that was in itself supported or given further support by the bespoke amendments that the parties had chosen to make, because they amended the 8.9 provision for employer default to extend the cure period to 28 days rather than 14 days, but hadn't given or hadn't made the same amendments to clause 8.4, so that the parties themselves were recognizing an asymmetry in the provisions, and there was no reason to construe them as having the same meaning. And then critically, the wording in the two clauses was different, and the words that made 8.4 unambiguously clear that you could terminate regardless of whether the right to terminate for continuation had arisen were absent in clause 8.9, and that difference must have existed, the court said, for a reason, particularly when you're looking at a standard form contract that's been very carefully considered and has evolved over time. One looks at differences in wording and must infer that the provisions were intended to operate differently. And so for those reasons, the Supreme Court rejected the reasoning of the Court of Appeal and supported Hexagon's case that Providence wasn't entitled contractually to terminate in the circumstances in which it purported to. The court also went on to consider a range of commercial and other factors, but the core of the reasoning is what I've set out. And I'm just going to draw attention to a few points that I think emerge from the judgment that are worth being aware of. The first, and this is a point that only the Supreme Court makes clear, the first instance judgment sort of skirts around the contrast between 8.9 and 8.4 and doesn't really come to any conclusion on it. The Court of Appeal came to the conclusion that both clauses operate the same way. And very importantly, the Supreme Court reached the view that clause 8.9.4 and 8.4.3 operate differently. And so those operating under or drafting contracts that include these JCT provisions need to be very aware that the employer right to terminate and the contractor right to terminate operate differently from each other. And if you're considering terminating as a contractor for employer default, it's much harder than the other way around. So be aware of that if you're asked to advise on or decide a dispute about termination in either case. Now, one thing that I think was apparent after the Court of Appeal's judgment, certainly a lot of people said this to me, is that they were amending the provisions in light of what the Court of Appeal had said, because they didn't like the conclusion that the judge had, the Court of Appeal had reached. And I suspect that contractors will equally want to insist on amendments as a result of the Supreme Court's judgment. Seems to me likely that parties will want to see parity between the employer and contractor termination provisions. I think it's going to be fairly difficult to reasonably object to that. So one can see in the future parties wanting to make them mirror images of each other. And that may be that you choose to make it operate as Providence said the clauses should be read, or you make them both operate as Hexagon said it should be read and the Supreme Court found. But I think symmetry is what parties will look for. And there was a slight dig at the JCT, I think, towards the back of the judgment, saying, well, if the JCT doesn't like what we've said about how these clauses operate, it's perfectly free to tidy up the drafting. And one thing that I think may also be worth noting in that regard is that when we got permission to appeal from the Supreme Court, we were asked to invite the JCT to intervene. I'm not entirely sure what use the Supreme Court reports the JCT would give, expressing its sort of subjective view as to the effort it had made on the drafting. Yeah. Needless to say, the JCT committee decided not to take the Supreme Court up on that opportunity to get some egg on its face. So no one heard from them, and we'll have to wait with bated breath to see whether or not they make any amendments in light of the judgment. I think another thing to be aware of is that the Supreme Court gave some guidance on the principles for interpreting standard form contracts. I'm not going to go into what those were, but this particular issue I don't think has reached that level before. There's plenty of guidance about this at the Court of Appeal level. The Supreme Court largely agreed with what the Court of Appeal has already said, but it's the first time that we've got guidance at that level. And it also gives some guidance on the use of guidance notes in interpreting standard form contracts. And just in short, it says guidance notes are admissible. They're very rarely going to be helpful, not least because they're caveated to the hilt, saying speak to a lawyer if you've got any interpretation issues. And it's not ever clear whether the drafter of the guidance note is the same person who drafted the contract. And even if it was, they would be just doing nothing more than expressing their own subjective view as to what the provision means. And so, yes, admissible, no, not likely to be very useful. And then just finally, some reflections on how three courts managed to reach different conclusions on the meaning of three little words. And I say three courts, different conclusions. Obviously, the first instance judge in the Supreme Court reached the same conclusion, but their reasons for their conclusions differed. So I think the first point to notice is that the clauses are genuinely ambiguous. The drafting is not the best, with all respect to the JCT drafting committee. And so there was scope for argument either way. I also think that policy may have played some role in the Court of Appeal's decision. Of course, I would say that. Others may feel that policy plays a role in the Supreme Court's decision. But during our submissions in the Court of Appeal, we were pressed quite strongly on the question, does being late in paying that many times amount to repudiatory breach or not? No matter our insistence that wasn't an issue before the court, and it was a matter that the adjudicator had decided in our favour, and he was the only person who'd looked at it, and the court didn't have the facts available. It was quite clear that both Coulson and Stuart Smith were troubled by the notion that you could repeatedly pay late and effectively give yourself a further 28 days in your payment process on our reading. And so I think that played a significant role, subconsciously at least, in motivating the judgment. Now, in the express terms of the judgment, they say they weren't particularly assisted by arguments over commerciality. They could see a commercial justification on both readings. But I do think that was going on at the back of their minds. I also think another thing that was going on in the back of the minds of the judges in the Court of Appeal, particularly being experienced senior construction judges, was how the JCT used to operate. So these provisions that were in issue here were introduced in the 2005 form of contract. In the earlier versions of the JCT, it was unambiguously clear, albeit it had never been decided in any authority. There were sort of over-to comments in some of the authorities that made it clear, and the clauses themselves made it clear, that the termination provisions used to operate as Providence was interpreting the present ones. And I think both Stuart Smith and Coulson would have come to it as judges who, when they were in practice as barristers, had understood these provisions to operate as Providence was saying. And so their gut instinct reading the clauses is that they still operated in exactly the same way. Again, in the judgments in the submissions of the parties, there were various discussions about the relevance of the history of the form, and at every level, the courts say we're not assisted by this. They refer to it dismissively as archaeology of the form. So everyone's just sort of digging around in the dirt, looking at previous forms of contract. But although in express terms they didn't find that useful, I think, again, subconsciously, that probably did play some role in why the Court of Appeal reached the decision that it did. So that's it from me.
Thank you very much.
No questions.
Thank you very much. And can we all thank Nick for that today? I will say, Nick, you're obviously hugely experienced, having been in the High Court, Court of Appeal, and indeed the Supreme Court. Never under the conditions you've suffered today, though, I dare say. So, look, thank you very much. Thank you for your unflappability and perseverance. It's fantastic. And I'll open it up now to the floor, or perhaps online, if we have any questions coming in. Mark, you raised your hand.
Well, Nick, as you know, and just to say, you'll need to repeat the question. So I'm going to make a comment first. I actually watched the Supreme Court hearings, which were fascinating, but it's at least 2 or 3 hours of my life I'm never going to get back again, talking about specific clauses of the JCT. But to come back to your principal point there, in simple terms, practical terms, what would you amend to make it easier for Joe Public, who's running a JCT contract? Now, I know that the answer may differ depending on which side you're advising, but in simple terms, what would you do to clarify things?
If I may, I'll just repeat the question for the benefit online, because I'm wearing a mic. And Mark's question was, what would Nick advise a party amend to make the JCT easier to operate for a standard user? Bearing in mind that may vary depending on the party you're advising.
It's a very good question. And it depends partly on what you're trying to achieve, of course. If you want to achieve a reading that Providence was arguing for, it seems to me that the fairly simple solution to that would be to excise all of the wording that was controversial. So you would make both 8.9.4 and 8.4.3 just say, if the default is repeated, then you can terminate. Simple. If you want the clause to operate as Hexagon was arguing for, and the Supreme Court found it's difficult to know how else you could word it to achieve that effect, other than the way that it is worded, which I think is why the Supreme Court ultimately came to the conclusion that it did. It's the only wording that really gives it that effect. I suppose you could say expressly, if for any reason the notice isn't given, and then you put in brackets whether or not, you say, sorry, the other way around, it'd be, and only if the right under 8.9.3 had arisen, if you're being extra pernickety about it. But I think that wording in itself achieves the effect. And I think the issue that parties will now want to grapple with is whether you should make the two clauses word the same. And I think as long as you have the same wording in both, there will be less cause for confusion as to how these provisions operate. I don't know whether we would have got to where we got to if the two provisions had said exactly the same thing. Okay.
Sort of saying really, going back to that symmetry point, making symmetrical.
Yeah, so the question was, is it worth making the clauses symmetrical? And that, I think just for reasons of fairness, one would want to do that. But the question of ambiguity, I think, arises particularly because the clauses are worded differently, and you can read into the differences whatever you want to read into it. And so I think if you give them symmetry, there's less likelihood of argument. Yes.
My jurisprudence, but general. So I don't do a lot of contract work anymore. But you mentioned in the early talk about the contract, the words of contract being influenced by common law, which goes back to William the Conqueror and probably before, does it not? If you write a contract and it's well drafted, why doesn't that stand up? Why does common law interfere with it? It's either in my simple non-legal mind, it would be either or. I mean, I know about common law. I mean, there's another thing. Can equity interfere with a contract? I'm out of my depth. It's not my pay grade, but I do some expert witness. It worries me. There's a contract goes out, and someone said, no, we're appealing to common law, which I might not know very well. Can you explain how that?
Yeah. So
the machinery that works on that.
If I can just repeat the question, perhaps slightly more concisely, the question is essentially about the interaction of the contract and common law. In part, I think, or part one was how the interpretation of the contract might be informed by the common law, and then secondly, the interaction perhaps between those two. Yeah.
So I suppose the straightforward answer is that principles of contractual interpretation, going back to basics, say that it's only where a clause is ambiguous that you can draw on anything other than the language of the provision. So insofar as you've drafted a clause well, the question doesn't arise. Where the question does arise is if the clause is ambiguous, and again the authorities are clear that you shouldn't go looking for ambiguity so that you can come up with some creative reading. It has to be genuinely ambiguous. And where it is ambiguous, I think it is important to be aware of what the common law principles are, because they are the background against which the contract operates. So if you've got a contractual provision, if you don't have a contractual provision governing particular circumstances that you're talking about, the thing that applies by default is the common law. And so the contract in effect is operating to alter the position that would apply by default, which is the common law position. And so it is important context where a provision is ambiguous.
I mean, the very nature of doing most of this is better than it may be architects, but even architects are unknown. So I have done repairs on a building and you don't know what you're going to find. So sometimes you open up and you allow for some contingencies, but I'm not God. I haven't got X-ray eyes. And you can't allow for every contingency. Otherwise, obviously drafted well, unambiguously using English language, very good thing. But is it sort of like a catch-all if that's falls through and someone says, well, common law says this, it goes back to common law? Is that the sort of principle?
Yeah, just very briefly, I think the question is whether or not common law then acts as a catch-all for instances in which the contract does not provide.
Well, you haven't thought of every contingency.
Yeah, it will depend on the circumstance, but it's the default position is what the common law provides, and then the contract can be consistent with that, or it can alter it if the parties choose to do so.
Thank you very much. Oh, we have another.
About your sort of interpretation of how the Court of Appeal might arrive at their decision policy. And I guess at the heart of this, it was late payment that was sort of the driving force. Are you aware of whether the sort of recent last year's government consultation on late payment considered any of the factors that arose in this particular case?
Sorry, so the question is whether the government's recent consideration of late payment and perhaps forthcoming legislation has taken into account any of the factors which were raised in the Providence and Hexagon case.
Yeah, I'm not aware of them specifically being aware of these sorts of issues. They're obviously generally concerned about late payment of commercial contracts generally, and I think there is in the report that was published recently on the consultation, there was concern about the construction industry in particular. It would be interesting to see whether any amendments are proposed, not merely to retention, which is what the legislation that they're drafting is currently focusing on, but whether there's
two parts, isn't there? The second part is to do with payment terms. 60 days coming in,
Yeah.
to 45.
Yes, yeah. So that will obviously have implications, not so much for the standard forms and not so much for the Housing Grants Act, which is all consistent with that, but with bespoke contracts that tend to provide for longer periods. And the Act allows flexibility there, where you can have much longer than the 28-day payment terms that apply under the scheme. And you sometimes see, 60, 70-day payment cycles. All of that will go. But I don't think there's anything that's looking specifically to amend the Housing Grants Act at the moment, but whether it's in need of it is an interesting question.
Do you think there's potentially an issue in which, where parties are, I'm just trying to think this through, required to have, say, 60-day payment terms where previously they've had 120, such as a famous one who's just gone bust or a few years ago? You might say that, Mark. What they could do is say, well, we have 60-day payment terms, but then we have a 60-day cure period. And in the same way that you've suggested, they might be buying themselves an extra 28 days, might be buying themselves, granted, you get the interest that comes with that, but they might be buying themselves that additional time.
Yeah, I think that is a tension in the whole of this litigation, the whole dispute. And it was a point that Providence heavily played on in their submissions. I think the point that you need to be very careful about is that this question was all about the circumstances in which you can terminate. Okay, it's not about the circumstances in which you're entitled to payment. It's not the circumstances in which you're entitled to adjudicate. It's not the circumstances in which you're entitled to suspend the works. It's just, when can you terminate? And Parliament didn't think it was necessary to give parties a right to terminate for late payment. If they had done so, they could have legislated for that. You have a right to adjudicate, you have a right to interest, you have a right to suspend. All of that is statutory. If you want to give yourself an additional right beyond what applies to statute, you've got to draft your contract to achieve that. And so I think ultimately that's why I didn't find the policy motivations to be a particularly persuasive reason for reading the termination provisions in a different way.
Fantastic. David, did I see?
You did, but I think Nick has answered my question. There is no authority, is there, to support the proposition that failure to pay is a breach. Indeed, I think there's authority to say, I will not pay you a penny.
Yeah.
Sorry, so the question from David is whether or not there is any authority which says that failure to pay, or indeed stating that I will not pay you a penny, is a repudiatory breach.
It's interesting you raise this question, because in the course of appeal, we have made the submission that a single instance of late payment wouldn't be repudiatory. And that seemed to us so obvious. And it was agreed by Providence's counsel that we didn't cite any authority for it, because it struck us as being self-evident. Lord Justice Coulson wasn't very happy about that. And he pressed, not me, but my leader on, well, what is your authority for that? And he wasn't very happy with the answer, it isn't in the bundle because it's uncontroversial. But there is authority to support the proposition that a single instance of late payment is unlikely to be repudiatory. It could be, depending on the circumstances, but in and of itself, unlikely. And that's, I think it's PVS and Vargo and Barrister, I think, off the top of my head.
Because it's not an act of bankruptcy, is it? You can't issue a statutory demand. You have to go and adjudicate.
Yes, exactly. And if you had an adjudicator's decision saying you're required to pay and then you refused, that might be a repudiatory breach. Possibly, again, depending on the circumstances. We're talking about, 50 pence, very unlikely. But if it was a substantial sum of money and you were point blank refusing to pay it despite an adjudicator saying it's due, that probably would be repudiatory.
Okay, we'll have a last one from Robert.
But are you saying then the approach is a kind of 3 strikes and you're out?
So the question from Robert is whether or not we're saying the approach is a 3 strikes and you're out.
I'm afraid it's not that straightforward. It depends on the circumstances. Here, in this case, there were 19 instances, but the sums were tiny and the periods were small. So we were talking, a few tens of thousands of pounds, usually late by 2 or 3 days. That wasn't repudiation. I think it's important to draw a distinction between late payment and non-payment. If you're consistently paying, but you're missing the payment dates by a few days, you're not showing an intention not to be bound. You're just not complying with the strict timetables. If you're point blank refusing to pay a sum that's due, that is a refusal to comply with, as an employer, pretty much your only obligation. And that is much more likely to be repudiatory.
Okay, thank you very much. And
Pleasure.
for the benefit of those online, we'll draw this to a close. So thank you very much.
Thank
And
you.
we'll thank Nick again.